Law Talk with Nick Maruchak. Thanks to MKI Legal, your trusted employment and family lawyers.
I fought the law and the law won. I fought the law and the law won.
Alrighty, Nick Maruchak from MKI Legal is in the studio, and 133 882 if you'd like to have a chat with him. Morning, Nick.
Good morning, Gary.
I've got to do just a couple of things here. First of all, we were speaking earlier about the gummy bear scare that had happened yesterday, where there'd been a warning by police not to take any gummy bears if you've found them or been handed them in the western suburbs because they had been laced with THC. I've had a bigger, broader discussion about gummy bears being used to put medicinal cannabis in, but that's another question. But police have just issued us with a statement. There have been charges laid in relation to these gummy bears. Perth detectives have charged a 16-year-old boy with a number of drug charges in relation to the manufacture and sale of cannabis lollies. It'll be alleged that the boy manufactured the cannabis lollies and sold 3 to a student at a western suburb school on Tuesday, the 13th of August. So there you go. Now, the lollies were ingested by the student and another female student, both aged 16. They required hospitalisation. So now this 16-year-old's facing a whole raft of charges. I won't go through them all, but 16, he's still liable though, isn't he?
Yep, it's going to go to children's court, and hopefully they can put him on a path to change his life and stay away from crime. And lucky he's under 18, because when he turns 18 and they do a criminal record check for him, it's all going to be clean. So that's good. His name can't be revealed in the media.
So he gets a chance now, basically.
He's got a chance because, he did it. If he did it 2 years later, 2 years older, it would have been a different story. So probably got a chance to turn his life around, but definitely old enough to be liable and responsible.
All right. Well, let's hope that he doesn't turn out to be the Heisenberg of gummy bear drug manufacturing, for those people who know the series Breaking Bad.
Yes.
He's a bit too young to be Breaking Bad and selling gummy bears with drugs in it. All right, Nick, let's get on with it. We've got on the line, this started with an email. We're calling the lady Anna. Hi,
Yes.
Anna.
Hi, Gary and Nick.
Hello, Anna.
Can we help?
I was in a relationship and it finished. Wasn't de facto, and the other party owed me a lot of money. So I wrote him letters and emails, and then a letter of demand, and he didn't answer any of it. So I put an application into this magistrate's court, civil.
Yep.
And he never answered that either. Then I put in for default judgment, and it was granted. And then after that, he got a lawyer to say she wanted that judgment set aside because we were in a de facto relationship and it belonged in the family court. So the judge asked us to put in affidavits, and when we did that and we went back to court, he said, obviously this is not a de facto relationship. So I thought it would go back to default judgment. But instead of that, he's asked for a half-day trial, and I have to provide witnesses to prove that he owed me the money.
Okay, so just a few things we'll break down. So default judgment is basically when you sue someone and they don't respond to the lawsuit, they get judgment automatically against them by default, right? So that's a risk. If you don't do anything, that's the risk for all the listeners out there. So you have to take action. How much money are we talking about?
$50,000.
Okay, $50,000 in the magistrate's court. That's good. So what happens is, it sounds like, and to be in the family court, you have to be in a de facto relationship, generally living each other for 2 years, right? So the judge made the decision that you guys are not in a de facto relationship. Is that what happened?
Yes, that's what happened, yeah.
Okay, so you had the hearing, and he was able to set aside the default judgment, but he wasn't able to convince the judge that you're in a de facto relationship. So is that what I'm following?
Yes, he set it aside on the basis that it belonged in the family court, and the judge said, no, it doesn't. It's not a de facto relationship, because I was able to prove that without a doubt that it wasn't.
Okay, so that's good. Now, it sounds like, I'm guessing here, he probably set aside the judgment because he can prove he's got an arguable case. Because to set aside a judgment, you have to prove that this case is arguable. So you don't have to convince the judge you'll win. You just have to convince the judge that I've got a chance of winning. So it sounds like, what was the money loaned for?
It was to do with a deal we made on a house, but unfortunately it was a verbal agreement and it wasn't put in writing. But I do have some evidence of that. And the fact that I'd written him many letters saying you owe me for this part of the house, and he's not denied it or written back, and it went to default judgment. And I thought the default judgment was that he had to prove we were in a de facto relationship to send it to the family law court, which he hasn't been able to do. So I thought the default judgment would still stand then.
No, but he can also set it aside on other grounds to say, look, he doesn't owe you the money. So
yeah, he hasn't said that though.
So then I'm confused why the judge would set it aside, because if it doesn't belong in the family court and he hasn't convinced the judge that he doesn't owe you the money, it's not going to get it set aside. But it sounds like it has been set aside and it's going to trial. Yeah.
Yeah, and I don't understand why, because it said that it was going to the family law court because this money that he owed me was part of a family law settlement, but it didn't go to the family law. So just by saying that he owed it to me and it's going there, he's admitting that he owes that money. But now I don't understand why we're now having a half-a-day trial when the default judgment was already there, and he's more or less admitted that he owed me that money. It's just weird.
So it's two things can happen. Either you're having a hearing about the default judgment issue and whether it's set aside or not, or you're having a hearing about whether he owes you the $50,000 or not, right? So you have to call the court to find out which one it is. And if it's a full-blown trial, I don't think it's going to be that. Probably, if it is a full-blown trial, you have to get your witnesses ready for the trial. So I'm happy to give you a call off air to give you a few pointers just to kind of make sure that that you know which way to argue.
Because obviously you don't have a lawyer at this stage, Anna.
No, I don't.
All right. Okay.
No, and I really don't have the funds to get a lawyer. I'm retired, but I think it's a trial. I have to prove he owes me that money when it was a verbal agreement.
Yes.
And so to get witnesses, you need to have someone who heard both of us saying about the verbal agreement. So that's difficult to do.
And look, and if you're the only witness, that's fine. So you want to get witnesses who maybe he had made admissions to that he owes you the money. You want to get any documents in emails or text messages that he admitted owing the money. But you collect all that. And if it's just you as the witness, that's fine. You just write down your story. You tell him, we had a discussion. We agreed that we'll both be liable for this debt. He agreed he'll pay me back. You put all that down in a witness statement, affidavit, in first person story, and put it before the judge. And then you have to cross-examine him. You have to, you get to cross-examine him by testing his evidence on the witness box under oath. And if he lies, that's perjury.
All right. Anna, I think we're keeping your number so that Nick might be able to have a chat to you afterwards, but appreciate that. Barry is the next caller. G'day, Barry. How can we help?
Good morning. I have a rental property, and the tenant passed away. The police found the next of kin, who happens to be an elderly lady who lives in Austria, and she doesn't speak English. She only speaks German. So I had to remove all these belongings and put it in storage. And now I'm sort of left with costs for removal and storage of belongings and restoration of the property, which cost a lot of money. So I'm up to about $6,000 in costs, and I'm stuck on where do I go now.
What kind of stuff did he leave? And
well, there's a lot of junk. I've kept valuable things like TVs, equipment, fridges. There's a car, and that sort of stuff. Can
he sell it? Can he sell that, Nick?
There is a process, right? So there is a process you go through to dispose of goods that a tenant has not collected, right? So you since the tenant's passed away, you want to communicate with the estate and give them a chance to collect it, because the next of kin. So it really depends on if the tenant has left a sizable estate, because if there's money in a bank account and if if the next of kin has a financial incentive to get involved, they might go through the process of going through probate or letters of administration to get authority to deal with his assets. But if he has no money and he's not really close with his family, they may just ignore it. So there is a process where there's a way to dispose unclaimed goods, right? There's a process where you go through and you have to advertise it, and then you sell it, and then you can reclaim all the cost of selling it, right? So I can just give you a call if you leave your number. I can tell you that process, but we can talk more about that.
Hey, Barry, how long has this guy been there?
I've been there for years.
Right.
I bought it, and where he was there, and of course, when we did the lease, he didn't put down the next of kin, so it took a while to find out by the police, because she lives in Austria.
Yeah.
Right. Is he Austrian too? Do you know?
He was an Australian by nationalisation.
Interesting story by the sound of it.
Yeah, so if it's just rubbish and stuff, you can throw it away. Throw it away. Goods of little value you can throw away. But if there's something of value, right, so there's some information on the Department of Commerce website, but you got to give them a notice. So you send a notice to the tenant that you're going to basically dispose of their goods. You give them a chance to reclaim it. They generally have 60 days. So you'll send the notice to the next of kin. And then if they don't do it, then you go through a process of selling it and discharging your liability. And you have to make an application potentially as well.
Okay. What's the car worth, I wonder, Barry?
The car would be probably 6,000 or 7,000, I would think.
Right.
The problem that I've got is I've got the lady's telephone number. I don't know what her address is or anything like that. That's the only thing that police would give me is the telephone number.
Right.
Yeah.
Wow. So you'd have to call her with an interpreter service.
Most likely, yeah.
Yeah. That's probably the only way to do it, mate, is with the old interpreter on the line.
And then magistrates court would be the court that you would go to do this. So I'll give the magistrates court a call, tell them about this, and then you can make an application. And there is like Uncollected Goods Act legislation that deals with this process, right? So it's but you can't just throw it away straight away. You have to, you follow the Disposal of Uncollected Goods Act process, go to the magistrates court, and you sell it, you recover all your costs, and then basically whatever's left over, basically, it pretty much gets to the government, and they will, it's like unclaimed monies service.
It's always, thanks, Barry. I hope Department of Commerce obviously is the website to go to start with, but maybe Nick can help you as well. But it just always amazes me when you have someone who dies and they're that alone.
Yeah.
There's no one else around that sort of comes to sort of deal with things like Barry has to. Fascinating. All right. It's 12 minutes to 11 at 133 882 if you'd like to speak to Nick Maruchak from MKI Legal. Back with more calls after this. Probably sneak in one, maybe two more. Nick Maruchak from MKI Legal. Rob's on the line. Hi, Rob. What's the question?
Hi, boys. It's to do with what you were saying earlier. If you have convictions, if you're under 18 and say you're going to go to America and they want you to declare all convictions, do you have to declare that one?
Okay. So so there's a few things going up here. I'm not an expert in American law, but I know in Australia, convictions under 18, you don't have to. They're fine. And also, even if you're over 18 and you have something called a spent conviction, right, where the conviction's wiped, you don't have to declare it. But when you go to America, I know for a fact that any convictions you have after 18, even if they're wiped, you have to declare. America has these really strict laws where they don't care about any conviction, even if it's wiped off your record, right? That definitely applies to adults. I'm not entirely sure if it applies under 18 years, right?
So I suppose when you do the application process, Rob, wouldn't it say, would it say the age, or does it just say declare any convictions?
Anything. I've actually seen them up. There's that, like you basically have to go through the green card process, or not green card process, this online visa.
Visa, yeah.
And you have to say, if you had any convictions, you say, yes, they automatically kick you out and you have to go to the immigration office. So you basically have to speak to a immigration lawyer in America, and then you might have to go and apply for a visa here locally at the American consulate.
Right.
So you have to speak to an American consulate, and then they'll ask you some questions about, are you still a criminal, all that kind of stuff, and then they'll have the consulate office here will have a discretion to give you the visa or not. So I just don't know if that applies for under 18, but definitely applies for over 18.
So, yeah, because what I'm trying to figure out, I suppose the wording would be the clue. If it says any convictions, you'd have to answer honestly. If it said any convictions since being, aged 18, then no, you don't. But if it just says any convictions, you would have to, and you'd been done for shoplifting or something when you were 14, you'd have to own up, wouldn't you? And then let the process take care of it.
So, so I'm just looking at a quick Google search here, and juvenile convictions are usually not examined by the US as long as it's been more than 5 years.
Right.
So that's kind of the quick Google. Thank you, Mr.
Not examined.
Yes. So you definitely, I would speak to an immigration lawyer, because if you get this wrong and you lie, they're going to ban you. And they find out they're going to, because there's data sharing between the Australian government, the US government, like if you go to, say, for England, and, England most certainly have the same laws as us. Under 18 doesn't matter. Even over 18, if it's been wiped, doesn't matter, right? But the US has very strict laws and they have this just very general requirement, any convictions.
The short answer is probably yes, but you know that if it's under the age of 18, they probably won't examine it too much. All right, okay. Hey, just one to finish with, just give me an answer on this. Do you think that a lollipop man who was operating in Victoria outside of a school, and he'd been doing so for years and years, he used to give like high fives to the kids a lot. All right, it was just a thing. He used to high five after they crossed the road or as they're crossing the road. Mm-hmm. He has been told by his employer, obviously the school, no longer to do the high five because a parent had complained that it was too intimate, too much physical contact with children as they're crossing the road. Do you reckon he's got a case to argue there? Should he argue about not being able to do a high five to the kids?
Look, I think the high five should be allowed, right? It's like, that's still fine with me. But if your employer tells you not to do something and it's a reasonable direction, you have to listen to them. And that probably counts as a reasonable direction. So if the employer makes a decision in that case, he has to follow it. And if he doesn't follow it and he high fives, he could get fired, and it might be a lawful firing. So I would just tell him to follow it, even though I disagree with the decision personally.
No fun anymore, is it? The world's becoming no fun. Apparently, the council in that area have told the lollipop operator, the man, that he cannot exhibit any behaviour with children which may be construed as unnecessarily physical.
Yeah.
All right. Well, there you go. The high five is out, folks. Thank you very much for coming in, Nick, and thanks for your help with all that.
Thanks so much, Gary.
Good on you. 133 882 is the talkback number. We're coming up to nearly 3 minutes to 11.